Okay, we'll go ahead and get started here. I'm Kerry Evander. I'll be presiding today. We have Judge Lambert and Judge Harris on the panel. Each side will have 20 minutes for their argument. Mr. Callaway, you're entitled to divide that time between opening argument and rebuttal argument. How much time do you wish to reserve for rebuttal?
Your Honor, I'd like to reserve 5 minutes for rebuttal.
Okay, and I assume you can both see the clock on the screen?
Yes, Your Honor.
Okay, so rely on that as well, but I'll try to help you. These arguments are being live streamed on YouTube so that the public does have an opportunity to view them. With that, Mr. Callaway, you may proceed.
Your Honor, before we do have 2 pending motions for attorney's fees. And I just wondered how the court would want to allocate time on that.
If you want to make that part of your argument, you may. As part of your 20 minutes.
Thank you, Your Honor. May it please the court, I'm Lawrence Callaway of the firm of Klein & Klein, LLC. We represent the appellants Winton and Thea Wilcox, the plaintiffs below. This is an appeal of an award of attorney's fees under section 704.04 Florida statutes. That statute gives the trial court the discretion to award attorney's fees where there is, I quote, an unreasonable refusal to comply with the provisions of section 704.012 Florida statutes. The provisions of section 704.012 Florida statutes set out the requirements for establishing a statutory way of necessity for a landlocked parcel of real property. As recently pointed out by this court in Vitelli versus Hager, 208 Southern 2nd 346. The burden is upon the party seeking an award of attorney's fees to show an unreasonable refusal to comply with the requirements of section 704.012. As pointed out in numerous cases cited in the appellant's brief, there must be a competent, substantial evidence on the record to support any award of fees. In the instant case, there is no competent, substantial evidence that the appellants unreasonably refused to comply with the provisions of section 704.012. Quite to the contrary, Your Honors, the record reflects that the appellants did everything they could to comply with the provisions of that section.
Let me ask you this. Is it your position that a trial judge can award fees against either the plaintiff or the defendant in this type of action, but that in doing so, the judge has to find that the party whom attorney's fees are being assessed against acted in an unreasonable manner in the litigation?
That's correct, Your Honor.
Okay.
I think the statute is pretty clear on that. Winston and Thea Wilcox owned a home in Summerfield, Florida that fronted on a dirt road commonly known as Southeast 145th Street. Southeast 145th Street was not a dedicated or public road, and access over the dirt road was pursuant to a non-exclusive ingress-egress easement recorded in public records in Marion County.
But they have access to it.
They had access to the dirt road. However, the easement creating the dirt road did not provide the appellants with legal access to a dedicated or public road. Directly across the easement and to the south, appellants were shut off and hemmed in from access to Southeast 147th Place by properties owned by
Southeast 147th Street, Sunset Harbor Road?
Yes, Your Honor.
Okay, so you want a statutory way of necessity across Ms. Vine's property to get to Sunset Harbor Road?
That was one of the alternatives, Your Honor.
Did you have access to Sunset Harbor Road by going on 145th Street until 73rd Avenue and then making a left there?
No, Your Honor, there was a 700, as the evidence showed, there was a 740-foot gap between the end of the easement and the county right-of-way for Southeast 73rd Avenue. And we took that into account when we filed an amended complaint, adding an alternative count for access over that route.
Was there a property owner that could preclude you from going down 73rd Avenue and reaching 147th Place?
Yes, Your Honor. There were multiples. We've joined them as defendants in counts 2 and 3 to complaint.
Well, And so Ms. Vines is not a party to counts 2 or 3. Is that correct?
That's correct, Your Honor.
Okay, so the lay of the land, I don't know if that's a pun intended or not, but right now, your clients can get down 145th Street, go down 73rd Avenue and get to Sunset Harbor, which is the paved road. Your concern, though, is that at some point, they may not be able to use a 740-foot portion of 73rd Avenue.
740 feet of what's shown as the dirt road of Southeast 73rd Avenue is private property, and we do not have legal access over it.
When you say it's private property, I mean, I know where I live, there's a dirt road in front of my property and it's got a street number on it, but I own half to the middle and the other one owns half. But I mean, I couldn't block access to it. I mean, is that what we're talking about here, the 740 foot?
No, Your Honor. In this case, it's not a dedicated road. It's not a public road. It's marked as Southeast 73rd Avenue, or at least that stretch, for EMS purposes, but it is not a dedicated or public road.
Okay. All right.
Anyway, appellants commenced this. Let me go back again, please. At the end of the easement, appellants were shut off and hemmed in from access to the county maintained right of way for Southeast 73rd Avenue by properties owned by various other individuals and entities. As stated in appellant's brief, when it came to providing legal access, Southeast 145th Street was essentially a road to nowhere.
So if you prevail on counts 2 or 3,
yes,
with
sir.
your, I don't know if it's implied grant of way of necessity or whatever cause of action, if you prevail on either or both of those causes of action, then your clients do have a way to get Sunset Harbor Road, right?
Yes, Your Honor.
Okay. And I guess I'm trying to, as best I can try to figure as to what Ms. Vines' complaint is, why am I being sued? And that's what's the unreasonable burden that's been placed upon her, and that she's entitled to fees, I guess, under 704.04. Why is she being sued? I mean, to get onto 145th Street or to go across her actual property?
To go across her property to Southeast 147th Place.
Well, why there as opposed to across the Cupsid's property? I mean, why are you choosing that route?
There was historically a Southeast 73rd Terrace, which was a dirt road shown on Google and other maps, that crossed Cupstead and Vines and went out to Southeast 147th Place. We attached that. As I said, appellants commenced this action initially as a single count complaint seeking an access over Vines and Cupstead's property using the route of Southeast 73rd Terrace and attaching a legal description of that route as an exhibit to the complaint. And we subsequently obtained leave of court and filed a 3-count amended complaint. Count 1 and 2 asserted alternative claims for a statutory waive of necessity. Count 1 again sought a waive of necessity over the properties owned by Applee and Cupstead. Count 2 sought a waive of necessity over the properties lying between the end of the easement and the county maintained right of way for Southeast 73rd Avenue. In each count, appellants pled all of the elements required to establish entitlement to a statutory waive of necessity in accordance with this court's decisions in Sorelli versus Ent and Blanton versus City of Pinellas Park. They established the necessity required for a waive of necessity by pointing out that they were shut off and hemmed in and without legal access, fulfilling the requirements of Messer versus Sonder, a first DCA case at 144 Southern 3rd, 566. In count 3 of their amended complaint, the appellants pled a cause of action for a prescriptive easement over the properties between the end of the easement and the county maintained right of way for Southeast 73rd Avenue against the possibility that the court might conclude that there was a, quote, apparently legal, close quotes, although not judicially confirmed prescriptive easement that needed to be addressed under this court's decision in Moran versus Bronner.
So is it your position today that basically this award of fees is premature because you may be precluded from getting to Southeast Sunset to Sunset Harbor Road if you don't prevail on 2 and 3, and therefore count 1 should remain active because that might end up being the only way that you can get to Sunset Harbor Road?
That's why we kept it in, Your Honor, in order to put everybody, as I said, our objective in pleading, as we did, was to put all relevant issues before the trial court in a single action to avoid the possibility of multiplicity of potentially inconclusive separate actions and subject all necessary parties and properties to the jurisdiction of the court so the trial court can make a conclusive and binding determination as to the proper location for legal access to the appellant's home. The trial court could first consider appellant's claim for prescriptive access over the properties between southeast, with the end of the easement and Southeast 73rd Avenue. If necessary, it could then, as part of the same action, consider alternative claims for a statutory way of necessity asserted in counts 1 and 2, and determine which provided the nearest practical route, considering the use to which the lands were being put in accordance with the requirements.
So Ms. Vine's position, I guess, or the counter to this is, if I'm understanding this, okay, look, you physically do have a way to get across the roads, the dirt roads to Sunset Harbor Road. You're concerned you might be cut off on a 740-foot piece of that. Go figure out if that happens first before you want to take a part of my land to get to Sunset Harbor Road, and so therefore, when you're prematurely suing me and causing me to incur fees, that's why you're not being hemmed in, and I should be entitled to fees under 704.04. Is that what she's saying?
That's what she's saying, Your Honor.
What's wrong with? I mean, where's the fallacy or the error in that argument that justifies us reversing the trial judge's order here?
Well, the fallacy in that, Your Honor, is that a plaintiff is entitled to plead in the alternative in order to minimize the number of lawsuits that he has to bring before the court, which is what we're doing here. The only thing that that appellee would be required to do in order to defend her position, if she had to do anything, was to present evidence, if she had to, as to the possibility of prescriptive access over Southeast 73rd Avenue.
Let me ask you this. In the order denying the motion to find your initial pleading to be a sham, the trial court wrote, plaintiffs have another practical means of access from property to Southeast 147th Street other than across the property of defendants Vines and Cubstead. And then it goes on, because plaintiff's entitlement to legal access across the 740-foot portion of 73rd Avenue is yet to be determined, the court does not find plaintiff's cause of action to be inherently false and not a sham pleading.
Correct.
What was the court referring to by saying you have a practicable means of access? Was your client already using that 73rd Avenue to get to 147th Place?
She was referring to practicable as a defined term in the statute, which means can be crossed without without a ferry, without fill or other obstruction. But there's other issue which is what comes up here, Your Honor. In the case of Matthews versus Quarles, it states that a property is shut off and hemmed in and entitled to seek a way of necessity where he or she is without legal access. So even if it's physical access, she's still entitled to obtain or seek a statutory way of necessity as preemptive in order to avoid a coastal cutoff if she does not have legal access. That's what we're doing here, Your Honor.
Okay, the county provided correspondence as far as your ability to use 145th Street. Was there any evidence on what the county's position was with regard to the use of 73rd Avenue?
I'm sorry, I understand.
Was there any evidence or any representations to the court by the parties as far as your client's ability to use 73rd Avenue, as far as the county's position on that?
Yes, the county did testify that it was not legal access, and at one point, even during the testimony, they said that they considered the possibility that the permits issued for the property were improperly issued because the parties did not have legal access. So if you're referring to the letter of February 5, 2016, he cautioned in that letter that 73rd Avenue had not been deeded to and was only partially maintained by Marion County. As set forth in the appellant's brief, in order for a road to become a public road providing legal access, there must be both a dedication and acceptance. As reflected in the record, the county confirmed the maintenance that could be construed as an acceptance ceased 740 feet south of the intersection with 145th Street. So as acknowledged by the trial court in his order on appellee's motion to strike, there was a 740-foot gap that kept the appellants from having the access which would preclude them from pleading an alternative count for statutory waive of necessity.
So count one is still pending, right?
Count one was stricken by the court.
Okay, I'm looking at the order. So it was granted in part and denied in part, the motion to strike count one. All right, and then count
Yes, Your
two, it
Honor.
says it's stricken. All right, so basically the case is over as opposed to Ms. Vines.
For now, Your Honor, it said that we had to proceed on our claims against the statutory waive, our prescriptive access or statutory waive necessity over Southeast 73rd first.
So you interpret the order to mean that if you then proceed against the other parties in counts 2 and 3 and you don't prevail, you have to refile count one as a new complaint?
Yes, Your Honor. Like the plaintiff in Brand versus Bronner.
Mm-hmm.
In that case, that the court found that if they denied the right to a statutory waive, a waive of necessity because of the possibility of a prescriptive easement, but provided in the decision that if the plaintiff pursued his complaint against the prescriptive access and was denied, he could come back at that point and file an action for statutory waive necessity over the same.
Let me ask you this, does the Vines property, it doesn't abut on 147th place, does it?
By itself, no. It's Vines and Cupstead combine the route for Southeast 73rd Terrace.
Okay, but directly south of the Vines property is a property owned by various other property owners?
That's correct, Your Honor. But what we sought was a way over the old Southeast 73rd Terrace, and there's a legal description for that route attached to our complaint.
Well, South 73rd Terrace, the abandoned road, is any part of that on Vines property, or was it all on what's now the Cupstead property?
Vines and Cupstead. It crossed over, started on from 145th, or it was on 145th Vines property, then it cursed to the west and then down to the Southeast 147th place across Cupstead.
All right, you're down to 2 minutes and 45 seconds. Do you want to reserve the rest of your time?
Reserve the balance for rebuttal, please.
All right, thank you. All right, Ms. Blackburn. You're muted.
At some point, I hope I get better with this. Thank you, Your Honors. Linda Blackburn with the Bicycle Law Firm for the appellee Mary Vines. May it please the court?
May I proceed? The
trial court's determination of ordering appellants to pay the appellee's attorney's fees in the underlying case pursuant to 704.04 was well within the trial court's discretion to do so. It was not an abuse of discretion, considering the totality of the circumstances presented to the trial court, both on the motion to strike and at the fee hearing held in this matter. It should be affirmed by this court.
How did
Blackburn, let me ask a couple of questions if I can, because I think on the record, probably there was no entitlement to an easement, but this is not a prevailing party statute. So tell me procedurally, those are, I think, the big concerns I have in this case. You filed a motion to strike count one. And the only grounds in that motion was that it was a sham pleading. The court said, no, it's not a sham. On what grounds then did the court grant your motion? If your only basis was a sham and it's not a sham, why was count one stricken?
Count one was stricken because they were not necessary. Appellee Vines was not necessary to the cause of actions asserted by plaintiff. They asserted a statutory way of necessity. They didn't have a need for access across Mary Vines necessary. And maybe I'm oversimplifying this.
Determined on a motion to strike?
On a motion to strike, we indicated that it was sham.
All right, well,
And-
and you didn't prevail on that part. So I understand that really isn't part of this appeal, but your motion didn't ask for attorney fees, right?
The motion to strike was in response to the complaint. There is no requirement of the law that when you don't put in your pleadings, or I'm sorry, a requirement is when you put it in your pleadings to request for attorney's fees, but you waive it if you do not do so. This wasn't a pleading, it was a motion to strike. So under the Florida Rules of Civil Procedure 1.525, we're entitled to come in after the fact and within 30 days of the court's order striking it from this action, we were entitled to move for fees pursuant to the court's order.
And pursuant to the statute. So that's what I want to talk to you about, because if you look at 704.012, that says that under this certain set of facts, an easement shall be created. It doesn't say there shall be a cause of action. It says there shall be an easement. And then it says that the owner of the property, and presumably the dominant parcel, can start using that easement, under this statutory way of necessity. So it doesn't say he has to file a lawsuit to get his easement. It says it's created, it's there, he can start using it, right?
Yes.
And then the owner of the servient parcel then is entitled to be compensated. So then if you go to 704.04, then it talks about filing a civil action. And it's only if your client in this case does not want him to use the easement that's already created until he or she gets paid, then either one of you can file a lawsuit, right?
That's what it says.
Okay, and then for fees, it says if either party has unreasonably refused to comply with previous one, 012, then there could be fees. The judge didn't find that. The judge's finding was what the plaintiffs did was unreasonably litigate, unreasonably pursue their cause of action. So that would be their action under 704.04 was unreasonable. What did they do? Point to me in 704.012, what did they do where they unreasonably refused to comply with 704.012? It just says an easement is created. That's all it says.
Under 704.01 sub 2, what did they do to refuse to comply?
How
One,
did they reasonably refuse to comply with that statute?
they weren't shut off or hemmed in by the lands of my client. Right out their driveway, they had access to a mutual grant of easement, which was
What does that statute tell them to do or tell them not to do that they refuse to comply with? They're saying this says, I'm entitled to this easement. I'm going to use the easement. They don't have to get court permission, at least initially, right? The easement's created by the statute.
Yes, and Your Honor, Mary Vines never blocked their access to Southeast 145th Street.
The judge's finding, though, is that they unreasonably participated in or prosecuted their lawsuit. That's
I think the judge's finding. Sorry, Your Honor, I didn't mean to interrupt. I think the judge's finding was that they weren't necessary to obtain access, so that in itself was unreasonable under the statute.
That's not what he said. That's not what she said. She said you unreasonably participated in the lawsuit or prosecuted the lawsuit. So that what they did that was unreasonable was violate 704.04. Where is her finding that they did anything unreasonably refusing to comply with 012? Which doesn't put any burden on them to do anything. So I don't know what they could refuse to comply with.
Well, Appellee Vines in this instance, and the court said in the transcript, and I can point you to the page, said that Appellee Vines was unnecessary to the cause of action to begin with. Count 1 was unnecessary for a 704.01 subsection 2 cause of action because they're looking for a way of necessity. They didn't need a way of necessity across Appellee Vines' land. It was unreasonable to try and seek a way through her property because it wouldn't have given them access to anything.
But seeking a way through the property comes under 704.04. So unreasonable doing is pursuing their rights under 704.04, according to the judge. But there's nothing they have to do under 704.012. You see my point, my distinction, or am I just confusing things?
Maybe I'm looking at this in an oversimplified way, but if they weren't necessary under the statute for a statutory way of necessity, then it's unreasonable for them to be brought into a lawsuit in order to get a statutory way of necessity.
Okay, so it's unreasonable for them to file their 70404 lawsuit.
It was unreasonable for them to file their 704.01 subsection 2 lawsuit.
Let me ask, maybe I understand the lay of the land a little better. I don't know why I keep using lay of the land, but is it your concern that, you know, when the complaint was initially filed, it was just one count basically against Ms. Vines, and she had to incur fees to defend herself against a cause of action that in her view should never have been brought. There was no reason to go across her property. Now, eventually, Mr. Callaway amended his complaint to add counts 2 and 3 to address whether he could actually have uninhibited use to the 740 feet on 73rd Avenue. And so that was kind of how it was presented to the trial court. And she looked at it and said, okay, you know what? Figure out those 2 causes of action first. And then we can get back to count 1 if we need to, either in this case or a separate cause of action. So I guess if Mr. Callaway had sued everybody at one time, initially in the initial complaint, then it could have been worked out early on to count 1, don't do anything. We're going to pursue counts 2 and 3, but we're going to, so we don't have to refile. We're just going to kind of hold count 1 in abeyance. If that had happened, your client really wouldn't have incurred much fees and we probably wouldn't be here. Is that a fair?
I think that's fair, but I also think that looking into the totality of the circumstances, if Ms. Callaway's client had looked at the lay of the land out there, in the fact that the north, east, and west portions of the Wilcox property is completely and wholly sitting on the Josephine Schuler estate, and had gone through the statute 704.01 subsection 1 and subsection 2, which the Parham and those line of cases indicate that he should have done, he would have discovered that there was no statutory way of necessity across Mary Vine's property, which is across the road. So there is access coming out of the Wilcox property to Southeast 145th. 704.01 subsection 2 indicates that you have to have access to a public or private way of access. There is a private way of access right there. That is all Mary Vines was ever required to do, was give that mutual grant of easement that her parents did in 1985, that was recorded in 1987. She did everything she was to do, and that's her way of access down Southeast 145th Street, south on Southeast 73rd Avenue, in order to access 174th. That's how she's accessed the property. That's how the individuals who owned the property before the Wilcoxes accessed their property. That's how Josephine Schuler and her kin have accessed their property. There's never been any blockage on that 740-foot strip of land on Southeast 73rd Avenue, nor does it touch or concern Ms. Vine's property. And so the bottom line is, if there was an issue as to it being a public dedicated road, that's not what 704.01 subsection 1 or subsection 2 is designed to do. It allows for access for landlocked property. It is necessity.
I think what Judge Harris is getting to with you is that, you know, 704.04 may not really be the vehicle, if you look at the plain language of the statute, that if this was a frivolous thing to bring you guys in the first place or sue you initially, you know, under 57.105, that would be the route that would have been the more statutory satisfactory route to get attorney fees here. 704.04 seems to suggest that if there's a right of way and then somebody is blocking it or causing problems with it, you can come to court and say, look, Judge, I have this right of way under 04012 and I can't get through it because they put a gate up or they put whatever, big boulders there or something. And therefore I've had to incur fees and, you know, make them fix it and pay my fees for me having to come here and spend everybody's time. That seems to be how 704.04 might be more applicable here.
I agree that 57.105 would have been a much cleaner way of getting through this. However, that's an extraordinary burden. I'm sorry.
Well, plus you lost because it's not, if they don't find it to be sham, I mean, I know there's different verbiage for 57-105 than the old days where it's frivolous from the inception, but you know.
And there were several motions for sanctions pending against the plaintiffs, not just by, Ms. Vines, but by the Cupsteads as well. And none of those came to fruition because at the end of the day, Ms. Vines got the relief she was seeking. She was dismissed from the lawsuit. And I mean, even the case that was cited by Mr. Callaway in this instance, the Raza v. Deutsch case, it indicates that if an order dismisses an action without prejudice and without granting leave to amend, it's a final appealable order. He could have appealed that decision. He didn't. And the court reserved jurisdiction to rule on attorney's fees. And we brought it before the court under 704.04, which I believe we were entitled to do so, especially based on Messer v. Sanders, that indicated that the individuals acted reasonably or unreasonably, which caused or did not cause them to get an award of attorney's fees. And I think that those words were exactly used. They acted reasonably, unreasonably. It was not reasonable at no time, whether it was the
case that was reasonable. What actions were reasonable or unreasonable? Wasn't it with regard to blocking access to the easement that the court found was unreasonable, not pursuing your rights under the statute?
Under Messer v. Sanders, Your Honor?
Yes.
Okay, under Messer v. Sanders, the court originally did not order the easement and did not order the appellant's attorney's fees in that regard. The easement was then reversed, or the finding that there was no easement was reversed, and the trial court still did not order attorney's fees, trial level attorney's fees to either party in that, because it deemed that both acted unreasonably. In this instance, defending this action, because there already existed an easement, there already existed access, there was no necessity, that was unreasonable to try and go across Mary Vine's land, because you're not going to be able to get access to 174th Place by going through Mary Vine's land. You're not going.
Where does Southeast 73rd Terrace go to? I guess that's
it. Your Honor, there was a individual at the motion to strike hearing, Michelle Hurst. She works for Marion County. She brought out the maps, the historic maps, and showed that Southeast 73rd Terrace that they're looking for access to is wholly and completely not existing anymore, but only existed on Manley Cupstead's property. It went up the flag line and stopped in the middle of their property. So it was a driveway, or converted to their driveway. And in order to get access to that, they could access Southeast 145th Street and go down Mr. Cupstead's property.
I mean, I'm looking at a schematic here, and it looks like the plaintiff's property, the west side of the plaintiff's property comes down on 145th Street, and right is at the intersection of the northeast boundary of Cupstead and the northwest boundary of your client. Right. So where does 73rd Terrace? Maybe where is that on your client's property?
It is not.
So they keep saying they want a statutory right of way on Southeast 73rd Terrace. Where is 73rd Terrace start? If I'm looking at 145th Street going west, where does 73rd Terrace come in?
73rd Terrace is a roadway that ran north and south solely and completely on Manley Cupstead's property.
Okay, on the property adjacent to your property.
Yes.
So in essence, tell me if I'm understanding what you're saying, to get to 73rd Terrace, which is their statutory right of way that they want, they would turn right out of their property on Southeast 145th Street, the dirt road that's got the mutual easement that your client's parents started. And then they would turn left onto Southeast 73rd Terrace, which is on the Cupstead's property.
It only ran halfway through, so they would have to get completely through the Cupstead's property.
To hook up to what? To hook up to what? 73rd Avenue?
To hook up to 73rd Terrace.
Am I saying this wrong? I thought 73rd Terrace is what he's asking for.
The 73rd Terrace is the historic route, and that exists solely and completely on Manley Cupstead's property. It is no longer
73rd Terrace. It connects to Southeast 145th Street, right?
No, it does not. It connects to Southeast 147th Place to the south.
That's Sunset Harbor Road, right?
Yes.
Maybe I'm missing something.
Okay,
He wants to, I know 73rd Avenue has the 740 feet. That's problematic to Mr. Callaway's position, right?
the 740 feet that's problematic to Mr. Callaway is on Southeast 73rd Avenue.
Right, but he's asking for a statutory right of way on 73rd Terrace, right?
As part of count one, yes.
Right, and that goes, and if I wanted to find Southeast 73rd Terrace, I come out 145th Street, correct? I go west, is that correct, out of his property?
Yes.
And then where does 73rd Terrace come in then?
In the middle of Mr. Cupstead's property. You have to cross
So
through.
Mr. Callaway's client would have to then drive across the Cupstead's property to get to 73rd Terrace, correct?
Which exists solely and completely on Mr. Cupstead's property.
And then the end of 73rd Terrace ends where?
Southeast 147th Place, Sunset Harbor Road.
Sunset Harbor Road. So that goes down. So you're saying Southeast 73rd Terrace then goes through Bobby Faulkner's property and Jack Sloan's property and hits Sunset Harbor?
Yes, down the flagpole.
And that's what count one is.
That's what count one is.
And count one, other than 145th Street coming out of the road to get to 73rd Terrace, that's your client's only involvement in that case is the 145th Street.
Yes, Your Honor.
Okay. All right. Thank you.
Ms. Blackburn, let me ask you this, kind of follow up to Judge Harris's questions. Was there any argument below that this particular statute 704.04 is not applicable to this type of situation, or was the argument solely on the basis that the plaintiffs did not act in an unreasonable manner, but acted in good faith, that they had the right to bring this case?
The only thing that I have ever heard in contravention to our argument for fees under 704.04 is that at all times the plaintiffs acted reasonably under the statute. I cannot point to any place where it was reasonable for Ms. Vines to be in this action at its inception. So I'm not exactly sure how it was reasonable when looking at the parroting of the statute in the complaint under 704.01 sub 2. There was no allegations that they were blocked in or hemmed off by Mary Vines' property. And the fact that they say that they needed legal access, well, they had legal access to Southeast 145th Place. They indicate that they're entitled to a dedicated or public road. They're entitled to a private road of access pursuant to 704.01 subsection 2.
Well, would you agree that legal access to 145th doesn't end the inquiry? I mean, if 145th Street went from, 10 feet west of the appellant's westernmost border and 10 feet east of the boundary of their property, they could go on a road for 20 feet, but it wouldn't get them anywhere.
And I would posit that Ms. Vines has nothing to do with the 740 feet that was never blocked and was always accessible that they're having issue with. Mary Vines' property is completely far east of that roadway. And so she gave all that she was required to give under the law in order for there to be access to go on down the road and get whatever it is you deem necessary. But no one is saying that there is a necessity here.
All right, well, your time is up. Let me see if the other members of the panel have any other questions.
I'm going to ask one more if I can, Ms. Blackburn. If the statute says if you feel your property is shut off or hemmed in, you have an easement. If it is shut off or hemmed in, if the other side disagrees, then either party can file suit in the circuit court to determine whether that easement actually exists. Can you think of any other case where the court has said that pursuing your statutory right to get a judicial determination is an unreasonable refusal to comply with that same statute that allows you to do that?
I don't know how it would be reasonable if you already have access. I can think of the Parham case, the Faison case, the Moran versus Bronner. All of them indicate that in order to bring this action, you have to have a necessity. And when there's a roadway right out front to your driveway, I don't understand how Mary
That might-
Vines.
The plaintiff loses, but this is, again, this is not a prevailing party statute. Was it unreasonable for him to get a judicial determination when the statute says you can get a judicial determination?
I believe it was unreasonable for him to seek a way of access across a piece of property that's across the roadway. And I believe that 704.04 would protect a subservient landowner in this instance for being hailed into court when there is no necessity, Your Honor.
Okay, thank you.
But one quick thing, is Mr. Callaway seeking attorney fees on appeal under 704.04?
Yes, Your Honor.
Okay, thank you.
Rebuttal.
That's you, Mr. Callaway.
2 points, Your Honor. There's been some ambiguity as to the location of 73rd Terrace. That is described in the exhibit to our complaint, which shows it starting at the corner of the Vines property and Southeast 145th Street, going down, taking a turn, and then going out through Cupstead property onto Southeast 145th.
So you're saying on the northwest corner of Miss Vine's property, there is some portion of Southeast 73rd Terrace, and that's why you sued her?
Yes, Your Honor. The legal description is
Okay,
attached
so
to the
what Ms.
complaint.
Blackburn was saying is that Southeast 73rd Terrace doesn't start until somewhere on the Cupstead's property. That's incorrect?
That's correct, Your Honor. We attached the legal description. We had our surveyor prepared following that route, and it's attached to the complaint as an exhibit.
Well, just give
Also,
me
Your
the
Honor,
description. I mean, I don't know how to put
sorry.
that all together, but go ahead.
She's also made an issue about the fact that we pursued an alternative route over Southeast 73rd. That ignores the case of Matthews versus Quarles. For the first DCA quoted Hill versus Kenny, stating, absent evidence that the plaintiffs had a legal and enforceable way in the form of a prescriptive easement over an alternative route, they had a right-of-way of necessity over defendant's private road, and the fact that plaintiff could have proceeded against another landowner for the same relief is irrelevant. So under Matthews versus Quarles, we were within our rights to seek access over Vines and Cupstead, as well as over the properties between us and Southeast 73rd. And
But if I understand right now, your clients have been unimpeded so far to get to Sunset Harbor Road. They're just concerned that they might be impeded at some point. So you brought the suit now. Is that right?
We brought the suit because of the possibility. Yes, Your Honor.
Right. I mean, but right now, if your client wanted to make a drive today to go to Sunset Harbor Road to get to Walmarts in the villages, Sunset Harbor to 441, there's nothing that has prevented them from doing that now or ever doing that in the past. And they may be able to do that for the next 25 years, as far as you know. Is that accurate?
We could continue to trespass over other properties. Yes, Your Honor.
Okay.
But the issue is, again, under Matthews versus Quarles, in order to be precluded from seeking a statutory way of necessity, we have to have confirmed legal access. We do not have confirmed legal access over Southeast 73rd or Southeast 73rd Terrace. We basically are on a road to nowhere when it comes to Southeast 145th Street. It goes, as Judge even just said, it takes us out a little ways and it stops us. We don't have legal access beyond the end of that easement.
Okay, your time is up. Any other questions from the panel?
No.
Nope.